There was a judgment that was given by the High Court on the 9th of February this year, and which judgment was based on a petition that had been lodged by some people claiming to be supporters and members of Jubilee Party, and by extension therefore Azimio, and who sought principally that the Speaker's ruling that had been made in October 2022 be nullified, for the reason that in their view the Speaker mistakenly granted the position of majority leader to the Kenya Kwanza alliance as opposed to Azimio. And of course, among the other issues that arose in those High Court proceedings was the periphery question of whether the Speaker of the National Assembly can hold his position as well as that position of other political parties, including that of the Kenya Kwanza Majority Alliance. Now, the matter came up for judgment on 9th of February this year, where the High Court agreed with the petitioners and nullified the Speaker's ruling that had slotted the Kenya Kwanza Alliance as the majority party in the National Assembly. And of course, among the other things that the court had talked about without making a finding was that in the High Court's view, it was not proper for the Speaker to hold the two positions. But the court went ahead and did that as a by the way. In other words, it's called obiter dictum, where there was no final decision made on that matter. Now, going forward, the National Assembly, which was the substantive party before the High Court, was aggrieved by the decision of the High Court and appealed to the Court of Appeal. Among other appellants who were aggrieved by the High Court decision, including political parties that had been adversely mentioned in the High Court judgment. At the Court of Appeal, other than filing the substantive record of appeal, the parties, including the National Assembly, also filed an application for stay, seeking principally to stay the High Court decision that had nullified the Speaker's decision on the majority leadership in the House. Now, before that application for stay could be heard, the Speaker of the National Assembly went ahead and made a subsequent, which I would want to call a second ruling, on the subject of the majority leadership in the House. And in the Speaker's view, the position remained the same, being that based on the prevailing circumstances that February, still the Kenya Kwanza Alliance remained with the majority members in the House. And that ruling of the Speaker stands to date. Nobody has gone to challenge that decision in court, and no court has pronounced itself nullifying or otherwise disagreeing with the position of the Speaker as to the current position or answer to the question of who is the majority in the National Assembly. The second issue that arose was whether the Court of Appeal ought to stay the High Court judgment based on its, by the way, notes on the decision of the Speaker to continue holding the position of the party leadership at the same time as the Speaker of the National Assembly. The Court of Appeal made a very interesting and correct decision that in their view, the High Court nowhere in its judgment made a final order demanding that the Speaker either vacates office as the Speaker of the National Assembly or as the party leader of Ford Kenya or as a co-principal of the Kenya Kwanza coalition. And therefore, in the view of the Court of Appeal, there's absolutely no threat to the Speaker of the National Assembly because no decision have been taken by the High Court regarding his holding of the dual role as the Speaker of the National Assembly and a political party player in the Kenya Kwanza Alliance.